bogey and turn yourself around.
I can.
Ready when you are.
Ready?
Alderman, did you have something prepared to say?
Yes, I did. I'm Karen Stennis, Alderman Ward 2. And I just want to say good evening and thank you for being here. Tonight was supposed to be a special call Board of Aldermen meeting. 2 aldermen called it under state law because of issues we need to discuss are serious, fully documented, and go to the integrity of the city government. As you can see, several of our colleagues chose not to attend. Without a quorum, this meeting cannot officially convene. But the issues do not disappear because the chairs are empty. The public still deserves to hear the truth. Had this meeting taken place, the Board of Aldermen would have heard 2 competing yet equally reasonable motions. The first was a motion to terminate the contract with City Attorney David Harris based on a clear chronological segment of events that have serious ethical concerns. The second was a motion to hire independent special counsel to review whether Mr. Harris's legal advice to the board was based on Mississippi law, whether it served the best interest of the city, and whether it met the ethical standards expected of public servants. Both motions were intended to protect the taxpayers, restore trust, put facts, not personalities, at the center of the discussion. Right now, in the absence of an official meeting, I'm going to walk through issues in public so the public understands why these motions matter. At the very first meeting of our interim city attorney, David Harris falsely documented in the official minutes a motion, a second, and a unanimous vote to continue the employment of a former city attorney and former Securex attorney Robert Wilkinson. These actions never took place. It was a fabricated phantom vote written into the official record to make it appear the board had agreed to something it did not agree to. Every alderman knew it was false. We voted unanimously to strike it from the minutes. That action should have been a wake-up call. Instead, it turned out to be a preview. Over the past few months, we've seen a pattern of actions that raise major legal and ethical concerns. These are not rumors. These are documented in meeting, videos, transcripts, emails, and contracts. I'm going to outline them in plain English. On September 2nd, the city attorney told the board his interim appointment would expire as a matter of law. If we did not sign a new contract with him that day, the city would be unrepresented and operating outside the law. He said Mississippi Code forced us to sign a 1-year contract with him that day, and that the law would not allow us to continue on a month-to-month basis while we searched for a permanent city attorney. Every one of those statements was incorrect. Mississippi law does not require limiting the interim period for city attorneys, and the statute he cited does not require a 1-year contract for city attorneys. But under pressure created by that false urgency, the board voted for a long-term contract he brought to us, one that benefited his own private law firm. That wasn't legal advice. That was contract negotiation by someone negotiating his own contract by using false legal citations. This was the first time we saw the law misrepresented in a way that created a personal financial benefit. On November 18th, while still searching for a permanent replacement, the board took up an RFP. It's a legal proposal. City David Harris was one of the bidders. That made him financially conflicted by definition. Alderman Pfieffer moved that he recuse himself and step out of the room, exactly as Mississippi ethics rules require, and the board voted unanimously to order that recusal. The mayor asked him to leave. He refused. His response, "I'll just sit here quietly." But under Mississippi law, recusal means leaving the room, not staying at the table while the board discusses your contract and applications of those we were considering as replacements. His refusal to leave was not consistent with Mississippi law and created a chilling effect on elected officials. When a public servant refuses to honor a unanimous vote of the governing body, that undermines the authority of the board and the integrity of the process. Later that same night, during the executive session, the board considered 3 proposals for entering a program to claim funds related to Forever Chemicals. City Attorney Harris recommended one particular firm. His presentation lasted about 15 minutes. About 12 seconds of that time were spent explaining his own involvement. The following day, we received details via email that recommended firm's contracts contained a clause stating that our board attorney would personally receive 15% of the contingency fee. In plain terms, he recommended a vendor contract where he stood to receive his own cut. This entire process was treated as confidential. We were instructed not to share the information. The law is clear. A public servant cannot recommend a contract that pays the public servant, period. These aren't personality disputes. These aren't disagreements over policy. These are concrete actions, fabricated vote, incorrect statements of the law that resulted in personal gain. A refusal to follow a unanimous recusal order, a vendor contract which he stood to personally profit. This is why we call this meeting, and this is why we are speaking to you now. Ocean Springs needs legal counsel that protects the public interest, not the personal interest. We must be able to trust the advice being given to us so we can make decisions that benefit the city and our residents, not David Harris. Thank you, and I'll turn it over to my colleague, Alderman Shannon Pfieffer.